And may it please the court, Your Honor. I represent Gail Collett, and if the court would indulge me, I'd appreciate it if I could give a little history of the factual background on this case. She is married, has two sons, and when she was a younger lady around 1985, she and her husband bought a brand new mobile home and set it out in the field in Livingston Parish. And not knowing what was happening, she started getting serious health problems after they moved into that mobile home. She lost 40 pounds. She was having problems breathing. It was a host of weird symptoms. Eventually, her ENT specialist asked her if she lived in a mobile home, and she said, yeah, they had the state sanitarian do an air sample, and it resulted in the finding of extremely high levels of formaldehyde in this mobile home. That was something that was going on in the 80s, and there was a great deal of reform eventually in constructing not only mobile homes, but using plywood and any presswood product and glues in carpet that off-gas formaldehyde. And now the industry makes those products in a completely different way. The offset of her illness at that time was that she became extremely sensitive to all chemicals. And she was desperate. They moved out of that mobile home and rented someplace after her doctor said she should. And her husband ended up in my office. I was working for a plaintiff's firm at that time. And he came in off the street and said he needed a bankruptcy lawyer because he had a note on this new mobile home and he couldn't afford rent and the note and the rest of the expenses for the family. And at that point, one of the lawyers in the office said, well, you might have a products liability case. And I was one of the young guys, so I ended up with the case. We tried it for a couple of years, and it settled.
How many years ago was that?
That was in the 80s. That was like
80s?
80s, 86, 87. And
long in the tooth.
Yeah, Gail and I were both young people at that time. She's now 69, 70 years old, and you know, she was desperate. I mean, she from that point on, she was just extremely scared of exposure, and she would have symptoms like she would start having heart racing, and she couldn't breathe very well. She'd go into all kind of distress, and it scared her that if she had an exposure bad enough, it would kill her.
Let me ask you about, you use the term exposure, and maybe we can be more specific to this case. Are we talking about, I think in the briefing there's the term drift. You use the term drift. Is that a wind-driven movement of a chemical through the air? Is that what happened in this case?
Yes, sir, Your Honor.
Is it a liquid like a spray, or is it something in gaseous form that she inhaled? Is that what you allege happened here?
Well, we know she had a reaction. I mean, the exact mechanism is, but what's undisputed is that the spray company came in, hired by Weyerhaeuser, and they have these giant tractors called skidders, and at each corner at the back, they have a big tanks on them. They have 3 nozzles that point to the side. They shoot high.
It sprays a liquid in a spray form, is that correct?
It does.
It's like a spray bottle you use at home?
Well, actually, it's high pressure.
No, I understand that, but I mean the nature of the substance is sprayed liquid.
That's right.
Okay.
And that and most other herbicides and pesticides have very stringent warnings in the label about preventing drift. It's not only to prevent human illness, but it's also to prevent drift to other fields and crop damage.
Okay, and now her complaint in this case is that she correct me if I'm wrong, or let's be clear, either smelling the chemical, coming into physical contact with the chemical, or just a fear from seeing them spraying and the smell of it, a fear that she was being damaged. Which of those, if not all, of the above, is she alleging here?
Well, the first day of the spraying was in the afternoon.
Right.
And there's no dispute that her son and she ran inside, she put towels around everything, and her son and her husband smelled the chemical in the air when they were outside of their house. And
But she did not in the afternoon.
that first afternoon, she did not. She testified that her heart started racing, but she said, I don't know if it was the chemical or if I was just scared. So she sealed herself in a room. She has a HEPA filter. She injects histamine when she has any kind of reaction. It was the next morning when she smelled the chemical in her house, and that was also the same morning that the spray company came back and at 6:30 in the morning. And what our meteorologist testified to is that there was a temperature inversion. That is expressly prohibited in the label for this herbicide and most others. You do not spray while there's a temperature inversion present. In Louisiana, the meteorologist testified that on 70 or 75% of the mornings in July, there's a temperature inversion just because of the characteristics of humidity and heat especially in southern Louisiana. So at that point, she had reactions that were worse. She covered her face. She said, I'm getting out of here. Her husband drove her to her parents' property, and she stayed in a camper that they owned for 5 weeks until she came home and after her family cleaned it up. That's the history. She that next morning, Monday morning. The first day was a Friday. Second day was a Saturday. That Monday morning, she called the Louisiana Department of Agriculture and Forestry. She didn't know anything about violations. All she knew is that in 2015, she had been included in the registry for pesticide hypersensitive individuals, which a number of states have.
Well, aside from the registry, is there an allegation that the defendants were negligent or did something? What is it exactly that they did that is actionable in this case?
Well, there are two bases. It's civilian. It's the civil code in Louisiana. One is 2315. It's a general negligence statute. The other is 667, which is a civil code article that imposes a duty on a neighbor not to use their property in a manner that's going to harm their neighbor. And that a long time, up until 1995, was constituted strict liability. The legislature added a requirement that the defendant knew or should have known that what they did might harm. The key to the case on Weyerhaeuser is that at one point they went and stayed on a mountaintop in Colorado. Her husband got a job in Colorado. They lived out in the woods, away from, outside of Estes Park. And after she got better, and after several years, her husband switched jobs, and they came back to their home place where her parents and her brothers and sisters live, which is outside of Angie, Louisiana, population 250. And at that point, she called everybody who sprayed and asked them, said, look, I've got these problems. She called the Rural Electric Company, she called the Highway Department, and she called Weyerhaeuser, who had an office in...
She got better in Colorado. Did she get well?
No. I mean, she got well enough. As she puts it, if I avoid chemicals, then I live a pretty normal life. But she has social distanced herself. And this is, she's undergone intense scrutiny by these defendants. They've looked at this is a big case, but she stays home. She'll go out to the doctor occasionally, and if she goes to see her son's family in Hammond, she might put a mask on and run into the bathroom at McDonald's if she has to. Otherwise, her church is around the corner, and the preacher records it and gives her a CD that's how intensely concerned she is about running into any chemicals. And she talked to Weyerhaeuser about it, and they were super nice. These people, the Forresters in the Weyerhaeuser office in Bogalusa, starting in the 90s when she came back, they remembered her. They all testified that she was extremely scared, that she told them, I'm sick, I can't be around chemicals, please don't spray by me.
What effect did it have on her exactly? What effect did the chemicals have?
Just you would look at it as like a severe allergic reaction. She has respiratory distress. Her throat closes up. She has the symptoms that she had here that were confirmed by objective symptoms was she had a pharyngitis. She had a red throat. She was wheezing, indicating an objective sign of respiratory distress. You can't, when you breathe in, you can't fake a wheeze. And she was talking in a hoarse manner, and she had sores in her nose. She also, that correlated with subjective symptoms of myalgia, weakness, and a number of other problems that are documented well by her family doctor in Folsom, Louisiana.
What evidence do you have of causation aside from, and I realize one of your issues on appeal, it relates to the treating physician. I think that's Dr. James. Aside from his report, which the district judge disallowed as to causation, what other evidence of either general or specific causation did you submit?
Well, admittedly, the Dr. James testimony about general causation is thin. He's a country doctor. She comes in. He's known her and her family for 30 years. He sees her all the time. Her son especially is a train wreck from a health standpoint. He knows the family well. He had in his file that she had an allergy test done by another doctor that showed heavy sensitivity to chemicals. He observed her one time in his waiting room. She got close to a lady who had perfume on, and he observed her having an allergic reaction to that exposure. She didn't sue anybody, but he knew about it. And then she comes in and has these objective symptoms of an allergic reaction. And he said, I believe her. I think she is.
He says chemical in general. He doesn't have any kind of ability to associate that. I think this is called arsenal AC, this particular chemical. Is there anything in the record to suggest, again, either generally or specifically to the plaintiff, that arsenal AC is the cause of what he discovered when he examined her?
Well, he linked it because of her honest...
because of her testimony. She said what happened, and he said, well, it has to.
And she came in the office shortly thereafter. His deposition was in two parts. He said, he retired this year. And he said, if I'm going to give a deposition, it's only going to be for 2 hours. Weyerhaeuser deposed him for 2 hours, and then it was over, and they filed their motion. I had to ask the court for them to reopen the deposition so I could ask questions, and that's where his testimony is. At that point, he said, you told me in the first session that it was arsenal AC, so I did some research, and I found out that there are all kind of warnings here and so that, it's thin from his standpoint, but that's not the only proof in the record about general causation.
Yeah, but that's what I'm asking. What is the other proof in the record?
Well, the other proof is the material data sheet that was discussed by her other doctor, Dr. Kraig, which also is in the record, and that's the material data sheet is produced by the manufacturer, BASF, and then the EPA label also has a great deal of warnings. You're required to wear up to standard respiratory masks and protective gear. It says do not use this if it could drift over and affect any other human being, worker, or anybody else. And so there is what the doctor said was one of the key things I saw when I researched it after Weyerhaeuser told him what it was. He said, "There's no human studies on this. It's only and our herbicide expert Hannah Mathers, who's a PhD, she cited a number of animal studies linking it to lung damage."
Your initial time has expired, Mr. Forrester.
Thank you very much.
Thank you, and you've saved time for rebuttal. Mr. Metcalf?
May it please the court, Joshua Metcalf on behalf of Weyerhaeuser Company. This case involves unsubstantiated claims of exposure to an herbicide that is less toxic than table salt. The district court did not abuse its discretion in excluding the speculative testimony of Dr. Mark James and properly dismissed plaintiff claims of negligent infliction of emotional distress. I'm happy to answer any questions the court may have about the Rule 702 exclusions or plaintiff's failure to properly designate Dr. James, but decades of Fifth Circuit precedent, particularly Johnson v. Arkema, support the district court's exclusion of the speculative testimony of Dr. James. With leave of court in my limited time this morning, I would like to address plaintiff's negligent infliction of emotional distress claim against Weyerhaeuser, as well as the preemption of plaintiff's Article 667 nuisance claim pursuant to the Louisiana Right to Farm Law. With respect to the negligent infliction of emotional distress claim under Article 2315, that claim for negligent infliction of emotional distress does not appear in any of plaintiff's petitions. Weyerhaeuser filed a motion for summary judgment early in the case, and in response, plaintiff didn't mention anything about negligent infliction of emotional distress. Weyerhaeuser filed its second motion for summary judgment, which is the subject of this appeal. Plaintiff didn't raise it in there. It wasn't until the court had excluded plaintiff's medical experts and Weyerhaeuser asked the court to reconsider the denial of its motion for summary judgment that plaintiff first raised the negligent infliction claim. And the district court analyzed that claim under Morrissey and this court's precedent in Neeson v. Trihawk. And the court methodically marched through the types of claims that are accepted from the general rule that you can't recover for emotional distress absent a physical injury. And the court walked through those and found that those did not apply. And the court focused in on Neeson v. Trihawk, which is a decision by this court, and specifically the trial court cited this court's language saying that the special circumstances which guarantee bona fide and genuine claims are not present when the claimant cannot prove he has been exposed to an injurious substance. So the court focused in on this lack of causation. That's something that this court has said is very important. And in that Neeson v. Trihawk case, the court said that to sanction...
that the chemical to which you've been exposed was no more than table salt.
Yes, Your Honor.
Does that mean that she was just exposed to one chemical?
Yes, Your Honor. Only one, we dispute that she was exposed at all. There is no evidence in the record that she actually was exposed to that chemical. But you're right, there was only one chemical that was being applied that day, and that is arsenal AC.
All of this focuses on one day?
There's 2 days. It's an afternoon and a morning. Yes, Your Honor. And
where do you get the statement that it was no more toxic than table salt?
I'll refer the court to the record, page 1313 as through 1316. And one of our experts, Dr. Andrew Zell, was a former head of the forestry department at the university, at Mississippi State University. And as part of his expert report in this case, we included a Mississippi State Extension Service article about the relative toxicity of various herbicides. And it goes through and it lists them out on tables, and it compares those herbicides to common things like table salt, aspirin, and others. And so Arsenal is essentially non-toxic. No, sir. No, Your Honor. It is, and the reason that I say that is, you know, a lot of these cases, particularly the negligent infliction cases, deal with injurious substances. So you're talking about blood that's been contaminated with AIDS. In Neesum case, it was literally brain matter that could potentially be contaminated with CJD that could alter a person's life forever. And another case that I would direct the court to that we've cited in our briefing is Anderson v. Dow Chemical, which is an unpublished decision of this court, but that involved exposure to vinyl chloride. And in that case, the court affirmed the district court's dismissal of summary judgment because the plaintiff could not demonstrate that they were exposed to a level of vinyl chloride that was high enough to cause the types of injuries they were claiming. Actually, in that case, in the Anderson case, vinyl chloride had been measured on the plaintiff's property. It was there. In our current case, the plaintiffs have admitted there is no property damage. We've got a report from the Louisiana Department of Agriculture and Forestry where they came out and they actually looked at the plaintiff's property and they found no evidence of any herbicide drift. There are pictures.
Examined by your doctors?
I'm sorry, Your Honor.
Was she examined by doctors chosen by you?
No, Your Honor. We did. We never actually got to the point of having her be examined by any doctors. We had a toxicologist, an MD, who we would have gone forward with. We submitted his expert report, et cetera, who analyzed the literature, all the epidemiology, and said, absolutely not, this is not related. There's a large body of epidemiology out there on imazapyr salts, which is the constituent that makes up Arsenal AC. And usually in these cases, we're talking about modeling.
Any medical evidence that this lady was essentially a hypochondriac?
Your Honor, that is what the Weyerhaeuser personnel felt. Those who testified felt that, you know, she believed that she was allergic to everything in the world. And Dr. James testified that he had treated her for a number of different things. He had never diagnosed her with an allergy to any specific thing. He'd never done any allergy testing for her and never did any in this case. But reading between the lines, she was at the hospital, at the doctor, over and over and over on all kinds of different things. So, Your Honor, not only is there no evidence of actual exposure to an injurious substance, which is required for a plaintiff to prevail on a claim for negligent infliction of emotional distress, all the other factors of how Weyerhaeuser conducted itself relating to Ms. Collett mitigate against this court expanding Morrissey further. So, for instance, Weyerhaeuser hired a licensed applicator. They provided them with a map of the area to be sprayed and indicated on there that there was a sensitive neighbor. They noted that a 100-foot buffer should be left. The Weyerhaeuser tree line it's undisputed, is at least 150 feet from the plaintiff's residence. So all of the factors and all the facts in this case support Weyerhaeuser's defense that its conduct in this matter was exactly what you would want a property owner to do. Unless the court has any other questions on the negligent infliction issue, I'd just like to transition briefly to the issue of the right to farm law. So Louisiana, like many states, has enacted protections for companies like Weyerhaeuser that engage in agriculture and that grow things and that defense is very important to Weyerhaeuser. Obviously, it owns a lot of land in the state of Louisiana and across the Southeast, and it's a responsible timberland owner. And in this situation, in this case, the trial court determined that the elements of the right to farm defense were met, and it ruled that Weyerhaeuser was entitled to the right to farm defense, but only with respect to the injunction claims that were brought by the plaintiff. And the trial court kind of parsed out Article 667 and said that Article 667 is not a nuisance statute. And it relied on a law review article from 1996, which is when amendments were made to Article 667, as this court has previously noted, to add in a negligence standard. And so the trial court, in sort of pulling Article 667 apart into two pieces, relied on the law review article, but we would refer the court to Brown versus Olin Chemical, which is one of this court's decisions from 2000, where the court stated, "We are convinced that the 1996 amendment to Article 667 applies to Articles 668 and 669 as well, so that stating a claim under one or more of these articles now requires a showing of negligence. The Louisiana Supreme Court has consistently treated these three code articles, which together govern Louisiana's nuisance law, as a cohesive unit, uniformly interpreting them in pari materia. As such, the 1996 amendment engrafted a standard of negligence on all three code articles and thus on nuisance law in Louisiana." So the district court, we believe, erred in not applying the right to farm law to all of Weyerhaeuser's claims, because 667, along, as the court said, with 667 through 669, is Louisiana's nuisance statutes. And in the right to farm law, the Louisiana legislature expresses a clear intent to preempt nuisance claims against companies like Weyerhaeuser. And in this situation, the plaintiff did not challenge Weyerhaeuser's proof or appeal the court's findings that the agricultural practices that Weyerhaeuser engaged in were generally accepted practices, that those were performed in accordance with the standards of standards of the agricultural industry, and that was supported by Weyerhaeuser's statement of undisputed facts. So we would ask the court to alternatively affirm the district court's dismissal of all of the 667 claims because they are preempted by the Louisiana right to farm law. If the court has any other questions, I'm happy to answer.
All right, thank you. Let you pronounce your last name. I'm not sure.
I will, Your Honor. May it please the court, and good morning. My name is Kraig Strenge, and I represent Thornhill Forestry Service. Your Honor, I'd like to get directly to the heart of the matter insofar as it deals with the alleged liability of my client, and that is that in wake of the trial court's exclusion of any causation medical testimony in this case, the only possible viable claim against Thornhill would be one for general negligence and resulting in the alleged negligent infliction of emotional distress. While there is some discussion of intentional infliction of emotional distress in some of the cases cited, that's not an allegation and not a fact in this case. However, Your Honor, it's not just a matter of general negligence. In this case, the bar is set higher because we're dealing with basically a case that would fall under the toxic tort line of cases. And in this case, there has to be extreme and outrageous conduct on part of Thornhill in order for there to be any recovery for negligent infliction of emotional distress. And the reason that's important is because this alleged outrageous conduct will have had to occur in a very narrow window of 2 days, those being July 6th and 7th of 2018. And the reason I say that is because there is absolutely no evidence in this case that prior to the spraying of this property that any of the Colletts had ever had any dealings or even knew who Thornhill was, and the reverse can be said for Thornhill. They had never had any dealings with the Colletts or knew who they were. So if there's going to be something that the plaintiff is going to try to point to as being outrageous, it had to have occurred on one of those 2 days. Now, this has been mentioned, so I want to touch on this, and that is the only knowledge that Thornhill had with respect to any type of sensitive neighbor was what has been referred to herein, which is actually called a herbicide activity map, but has also been referred to as a pre-entry map. And that is a map that is given to Thornhill by the Weyerhaeuser company with instructions on where to spray. That map contained one and only one reference to a sensitive neighbor, and it didn't say who it was or what the sensitivity was. It simply said maintain a 100-foot buffer, which we did. There is no testimony or evidence in this case that the 100-foot buffer from the plaintiff's residence was compromised. And in fact, there's testimony from an LDAF representative that the closest spraying, evidence of spraying that she could find to the Collett residence was 165 feet. So the buffer was maintained, and that was the instructions given to my client, and they followed them. Now, Mr. Forrester argued briefly this morning that, and I wrote this down, that the plaintiffs had called everybody who sprays. That would be an inaccurate statement as to my client. Nobody called me. Nobody called Thornhill or told them anything about the Colletts. Thornhill was going off the unit activity, the herbicide activity map that they were given, and that's all they knew. There's also been some argument about the 2 days of spraying, and at the very end of his argument, Mr. Forrester touched on, and I'm about to run out of time here, so I'm going to speed up as much as I can, touched on the fact that there was spraying on the second days and there was a temperature inversion. Your Honors, his own expert says on the first day there's no temperature version, and on the second day the temperature version is in Slidell, 50 miles away from where we are. The undisputed testimony from Marvin Thornhill is that the area directly across the road from the Collett home was sprayed on that first afternoon, and these, while it was not argued, there was, quote, 3 in-your-face conversations that supposedly took place. All those conversations took place after Thornhill had already sprayed directly across the road. In my 9 seconds left, that is corroborated by the testimony of Mr. Marvin Thornhill, by Gary Collett himself, the plaintiff's husband, and by Officer Hickman. I am out of time, but if you have any questions, I would be glad to answer them.
Thank you, Mr. Strenge.
Thank you.
Mr. Simmons?
Make sure I get my minute in. Good morning, Your Honors, and may it please the Court, Travis Simmons and Bill Lozes here on behalf of Lafayette Insurance Company. As you know from reading the briefs, we have a limited role in this case. We are adopting all the arguments, the briefing and the oral arguments of counsel for Weyerhaeuser and counsel for Thornhill, but we did want to reserve our minute to ask if Your Honors have any questions specifically to Lafayette Insurance Company. Your Honor, if there's no questions, you heard the oral arguments today. This is a case of medical causation. There's no evidence of it here. The plaintiffs failed to uphold their burden at the district court level. They failed to meet their burden at the appellate level, and so as such, the appellees respectfully request that the district court's rulings be upheld and that plaintiffs' claims remain dismissed with prejudice.
Thank you, Mr. Simmons. Mr. Forrester, you have some time for rebuttal.
5 minutes, I believe, Your Honor. If I can use my remaining time to address the issue of the standard of a summary judgment. The Morrissey case said that damages for emotional distress without proof of injury, which if you grant, I mean, if you uphold the district court's exclusion of Dr. James, that's what this case would, the remaining part of this case would exist, that the Louisiana courts would only award damages in that case if there were special circumstances that guaranteed the claim was not spurious. In other words, that the mental anguish wasn't just made up, which is a smart rule because it's subject to outrageous abuse in the tort system. So you have to have a very unusual situation, and you have to demonstrate that the defendant's conduct was outrageous in some way, shape, or form. Can a jury conclude that in this case? Well, let me tell you. For 20 years, she called Weyerhaeuser every single year. She pleaded with them not to spray. They didn't think, none of them said they thought she was a hypochondriac. In fact, they believed her, and when she actually was sprayed one time by a crop duster in 2004, and that Forrester, Paxton Tate, came out, and he said, look, Ms. Collett, I'm going to try to fix it so you don't get sprayed again. And he made a map, an aerial map, and he said, I'm going to circle your house on the aerial map and make sure that we will not spray within a quarter mile of your house. And he put it on the bulletin board in the Bogalusa office in a prominent place, and it was there until 2017. It was viewed literally thousands of times by Weyerhaeuser employees. And then in 2015, she gets accepted onto the registry of pesticide hypersensitivity that says anybody spraying should give prior notice to someone on this list. It gives the address, phone number, and GPS location. And so when it comes down to depositions, Weyerhaeuser said, well, look, we closed that Bogalusa office in 2017. We don't know what happened to Mr. Tate's map. We don't know what happened to the file. And we never heard of the registry of pesticide hypersensitive people. And they send the skidders out by Thornhill and show up unexpectedly. And they're saying that a jury can't find that's outrageous. After 20 years of her telling them how extremely scared she was of their spraying, they show up without even a phone call. And you tell me a jury can't find that's outrageous and that her claim is not spurious for mental anguish? Thornhill's attorney just said that they had no knowledge of her except for this little note on their spray sheet from Weyerhaeuser. Well, the state representatives had testified that the certified applicator at Thornhill, who had a Louisiana license, was physically given that list. And every applicator was given that list. But he didn't read it. He had never heard of it before. He didn't call Ms. Collett. And he was supposed to, by Louisiana law, was supposed to directly supervise his spray crew. So he goes out there, and they start spraying. The first day, right across the street, in the open, there's pictures of the spray coming out of the skidder. Her husband goes over there and says, there's a sick lady here. Y'all aren't supposed to be spraying here. What do? Well, tough luck. We got instructions, we're going to do it. Then a neighbor came over who used to work for Weyerhaeuser and said, there's a sick lady, you're not supposed to be here. And they ignored him. Did they call the supervisor? He was directly supervising in Mississippi at their office up someplace in Mississippi. He wasn't directly supervised. That's a statutory violation. And they didn't even talk to him about it until they got on the way home, where they obviously had cell phone service instead of out there in the middle of nowhere near Angie. And then you add the rest of the outrage. They're just, if you read our expert's report, there's spraying in a thermal inversion, all these things. He said, I'd never heard of a thermal inversion.
Your time has expired now.
Yeah.
Go ahead. I remind you, I kind of least learn this court sometimes about it, is rebuttal is for rebuttal. You're not supposed to make these arguments on rebuttal. It doesn't give the other side a chance to respond.
Well, I'll be glad to have him respond, Your Honor, but the,
those are the arguments you should have made in the first, and then you butt what they've said.
well, in my defense, we were sidetracked by the questions about general causation and Dr. James, and I ran out of time. I wanted to focus on the summary judgment standard and Morrissey, honestly, but when they started saying anyway, I appreciate the point.
All right, thank you, Mr. Forrester. Your case and all of today's cases are under submission, and the court is in recess until 9 o'clock tomorrow.